in a public forum is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, township, or agency present? Great. This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Okay, and one last time. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is an agent or member of any law enforcement agency of a federal, state, county, city, or township agency present? And this is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Perfect, and I'll close with our prayer. O Holy Father, bless our meeting with eyes to see and ears to hear the messages and information being presented with an open and caring and compassionate heart for all our fellow brothers and sisters, as it shall be done. Take it away, Glenn.
Let it be done. Okay, so I got my scheduling order. This is for the U.S. Court of Appeals for the Fifth Circuit. And so we're just going to go through this real quick so people, see what a scheduling order looks like. It's pretty simple. We have docketed the appeal referenced above. And in order to get that, I had to send them the appeal record, okay, the record, which is basically my exhibits, the stuff that I filed. Because what happened is I didn't do electronic filing in the lower court, and so the lower court doesn't send it electronically to the Court of Appeals. I have to do it. I had to burn it onto a CD and send it to them, and which I did, and that was in there on the website. It explained all of that. I've had cases dismissed in the past because they said we need the appeal record, and I said, well, the district court is supposed to send it, and anyways. So this was the stuff that was going on. So anyways, I sent it. And so this is the letter, the appeal brief. They actually dismissed it for failure to prosecute because I failed to pay the filing fee on time. Actually, they dismissed it on the same day that I paid the filing fee, paid their extortion. And so what happened is I think they knew that it got paid, and so they were just basically making a point. And so then I sent them a copy of the receipt, and they sent me a letter back saying, we're not doing anything with this. You got to do a motion. And so then I did a motion. And so then a judge didn't even rule on it. They just sent me a letter and said, okay, we've redocketed your appeal. Anyways, it's politics, So they docketed it. The record is now complete for the purpose of this appeal. The appellant's brief and record excerpts must be submitted within 40 days of the date listed above. So 40 days of June 4th, which means July 14th. So it's just basically a bunch of stuff to be aware of with the appeal stuff. They kind of babysit you a little bit, which is okay. I don't mind that so much. I got to look into the rules and see what it says about filing paper copies versus electronic. It says paper copies not required. Brief covers, and when you're in the Court of Appeals, they like the appellant's brief is supposed to be blue or something like that, and then the appellee's brief is maybe lavender or pink or something like that. You see what I'm saying? And they want all of this stuff to keep it simple so they can look at it easily. You got to babysit these judges so that they don't get things mixed up. And anyways, so and then if there's
No, they call it a trial book here.
call it a what?
A trial book.
I guess. Actually, when I did it in Canada, it was called a what was it called? It was called a oh man, I can't remember. I did it in Ontario. I filed an appeal in Ontario, and um, it's been a long time. Anyway, so this is just a lot of stuff to cover, stuff that I have to do, um, and they probably see. It doesn't say anything when the appellees have to have their stuff. Oh, reply briefs. Cases are not generally submitted till all briefs are filed. Reply briefs must be filed within the 21-day period specified. And that's if the appellees file a brief, then and I want to reply to it, then I got to go to the rules and see what it says. And I gotta it says they'll dismiss it if I don't follow the rules, and I'll probably have to send them a notice of appearance that I'm appearing for myself. I'll probably send them something like that. Here, I got 2 weeks, and so they even have templates that I can use, and it talks about the electronic file. So I got to go through all this stuff. So I got to start, looking at this and preparing my. And that's it. This is it. And then they're copying in all these other liars, which is 2, 4, 6, 8, 10 other liars. And
So you have to serve all them as well?
yeah, probably when I file my appeal brief. Yeah. Yeah. When I prepare it, I'll serve them a copy too.
By registered, correct? Not
No,
by
just first class
certified.
mail. First class mail is all it's required.
Okay, because a lot of folks are having issues with that.
Now, if I did it electronically, then I wouldn't have to send them by snail mail. And so the electronic is actually more convenient. But the problem with electronic is you have to give them a credit card. And when you give them a credit card, you're giving them evidence against you that you're one of the slaves. And so that's why I really refrain from that. So we'll see. I got to read the rules and see what it says. Um, read the rules, and they're steering me to certain rules here right now. Fifth Circuit Rule 28, 30, and 31, and 30.1.2, Fifth Circuit Rule 31.1. So there's some local rules. I got to go through and look at all that stuff. And anyways, it's been docketed.
Yeah, formatting, and they want it in a trial docket. So everything is bound together. So
Yeah.
there's no issue with it being misplaced, is what I read previously.
Yeah, factum. That's what it's called. In Ontario, when I filed an appeal, it was called a factum, and I filed some factums. Anyways, um, so so this is what it looks like. So that's about it. Let's go to the notice of void judgment. This is something I've been working on. This is in the case that I'm appealing from. And so I modified the mandatory judicial notice. So a lot of stuff in here that was in the mandatory judicial notice of 12 presumptions, and I did it in the form of an affidavit. Let me see if I got to share it here. Just a second. Okay, I'm back.
Awesome.
Okay, so what I have to do is notice of void judgment right there. There we go. Let's make this bigger so it's easier to read.
It should be examined too why it's not an obligation for one court to notify another.
They're all a bunch of pirates. It's the Vatican. You got to understand, it's the Vatican. There's no such thing as justice is going to go on in there.
But there's got to be something in that UN material that says they're not obligated, which is what all this problem always stems from.
It's the Vatican. It's a dictatorship. They can do anything they want. It's the Vatican.
The
It's
big
Roman
blue
law.
sea. The big, deep blue sea.
Okay, so let me just verify that this is streaming on YouTube. Oh, yep. Yep, sure is. Okay. Looks like we got some viewers too, although there's nobody chatting yet. Okay, so let's. This is the notice of void judgment, and I'm doing it in the form of an affidavit. All facts stated herein are true, correct, complete, not hearsay, not misleading, but are admissible as evidence, if not rebutted and proven inaccurate, and if testifying, I shall so state. And these are just the standard clauses that I put up at the front. I'm a flesh and blood man, sovereign individual in a collective capacity with other sovereigns. I have standing capacity to act in the lawful matters herein. I have personal, executive, and documented knowledge of the facts stated herein. I have no first-hand knowledge of my date of birth, except to say that I was told I was born on or about the year 1957. Any evidence anywhere about my birth is hearsay evidence and inadmissible as evidence in any court, because both of my parents and the attending physician at the time are now dead, and I have not had the opportunity to cross-examine them in a court to determine the veracity of their evidence. Having said that, I do remember finishing high school in the year 1975. Therefore, I'm well past the age of majority. In absence of the contrary evidence, I am a free man on the soil of Texas and other American states from time to time, and devoid of any knowledge of surrendering or volunteering myself as a government employee or to the armed forces of any country, and devoid of any knowledge of surrendering myself to the District of Columbia or their U.S. citizen scam, or their Sestake Trust scam, or their Vatican Corporation, or fictitious entity scam as found in the Affidavit of Corporate Denial 06-2013, which is recorded with the Pinal County Recorder at P number 2013-032373, and hold any respondents to the strictest proof to the contrary. I have many good and honorable servants that work for governments on Turtle Island. Turtle Island is what the First Nations people call North America, at various levels, and I have no idea what they get paid. But in my opinion, it is not enough, because we need people to hunt down thieves and murderers and keep the peace. And I'm cognizant of my duty to come to their aid when needed. But when they perjure their oaths and engage in unlawful activity, it's my duty to bring their crimes to light and to do everything I can to make sure they are brought to justice. The use of any statutes, codes, rules, regulations, and court citations within any document created by me at any time is only notice that which is applicable to government officials, and is not intended, nor shall it be construed to mean that I have conferred, submitted to, or entered into any jurisdiction alluded to thereby. Will Livingston ratified this Constitution for the United States of America on behalf of New Jersey, 1787, is my fourth great uncle, which means I am posterity as found in the preamble. we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. So, secure the blessings of liberty to ourselves and our posterity. And I'm entitled to right of blood. And right of blood cannot be destroyed by any civil law, because all the laws of Congress and all the laws of Texas are civil laws. And this is the maxim right here, Bouvier's Law Dictionary, 1856 edition. And this court is operating under power which is derived from me as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. Another maxim. Therefore, it's impossible for me to give any of these wrongdoers, or their bar member handlers, or this court any authority over me. And John Marshall, the Chief Judge of the Legislative Supreme Court of the United States, agreed and said it's impossible for me to confer sovereignty which will extend over me. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority, is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws, made in pursuance of the Constitution, are declared to be supreme. Consequently, the people of a single state cannot confer sovereignty which will extend over them. I am exempt from these wrongdoers and their Vatican corporation and their Vatican-owned and operated private bar guild handlers, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that's U.S. Supreme Court, Kawanakoa versus Polyblank, 1907. And I required this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or their property belonging to the United States, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding. Article 6, Clause 2. And we the people failed to be U.S. citizens because the 14th Amendment U.S. citizen failed to exist when the Constitution was written. And the term citizens of the United States must be understood to intend those who were citizens of a state as such after the Union had commenced and the several states had assumed their sovereignties. Before this period, there was no citizens of the United States. A U.S. citizen is a fiction of law. It might be correctly said that there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be called a citizen of the United States, although technically and abstractly there is no such thing. And this is Public Law 100-418, August 23rd, 1988. The term United States business means a United States citizen, so it's a corporation, it's a fictitious entity. Fictions of law were invented by the Roman praetors under canon or Roman law for the Pope's ecclesiastical city-states, which is now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, page 520. And fictions of law owe their origins to the legislative usurpations of the bench, which means the fake judge becomes a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial. And this is United States versus Lovett, U.S. Supreme Court, and that's what it says right here. Bill of attainder is a special legislative act prescribing punishment without a trial for a specific person or group. So and I'll explain this more. When they issue an order against me, because it's against this fictitious entity, then their order is a bill of attainder. Bill of pains and penalties A legislative act that, though similar to a bill of attainder prescribing punishment less severe than capital punishment, a bill of pains and penalties are included within the U.S. Constitution's ban on bills of attainder. Because judges only hold office during good behavior, and that's Article 3, Section 1 of the Constitution, and judges in bad behavior engaged in fraud upon the court. Fraud upon the court is fraud which is directed at the judicial machinery itself and is not fraud between the parties or fraudulent documents, false statements, or perjury. It's where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function. In other words, where the impartial functions of the court have been directly corrupted. Therefore, fake magistrate Judge Hal R. Ray, in conspiracy with fake Judge Reed O'Connor, issued a bill of pains and penalties against me, the named individual, because they intend to be accomplices to the theft of my land by using their Vatican-owned and operated fiction of law. Texas tax code originated with an act defining what money and property is subject to taxation or exemption, and the mode of listing the same on August 21st, 1876. And it says, Section 1, the property of corporations now existing or may hereafter be created, or property of all banks, banking companies now existing or hereinafter created, and all bankers. So that's who gets taxed, which is for corporate-owned property. In Section 4, the term person, whenever used in this act or any act relating to assessment or collection of taxes, shall be construed to include firm, company, or corporation. Requires cash or its equivalent for their taxes, which means Federal Reserve notes. And this is Section 104. Definitions, Texas Tax Code. Market value means the price of property which was transferred for cash or its equivalent. And as explained in the Catherine Phillips Notice and Demand that was served on the wrongdoers, taxable land is land used for the production of income or controls or manages as a fiduciary. Rendition, generally. A person shall render all tangible personal property used for the production of income that the person owns or that the person manages or controls as a fiduciary. And rendition originated with Section 7 in the Act of Legislature of 1876. Section 7, all property shall be listed or rendered in the following manner. First, every person of full age and sound mind being a resident of the state, which is corporate property, which means the demandant's land fails to qualify for rendition as explained in the notice and demand that was served on the wrongdoers, because income is corporate profits. And this is U.S. Supreme Court, Eisner versus McComber. It becomes essential to distinguish between what is and what is not income. According to truth and substance, without regard to form, Congress cannot, by any definition it may adopt, conclude the matter, since it cannot by legislation alter the Constitution from which it derives its power to legislate, and from which those limitations alone that power can be lawfully exercised. Income is derived from capital. The gain derived from capital. And this is, I looked this case up, and the emphasis is in the original. Okay, so the bold and underlining, that's all in the actual book. Here we have the essential matter. Not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value severed from the capital, however employed, invested or employed, coming in and being derived, that is, received or drawn by the recipient for his separate use, benefit, and disposal. That is the income derived from property. Nothing else answers the description. So it's corporate profits is what they're talking about there. BAR is an acronym which stands for British Accredited Regency. Regency is the office or jurisdiction of a region or body of regents, a government or authority of regents, a period during which a region or body of regents govern. Regent. Oh, I need to modify that. There we go. Regent, a person who exercised the ruling power in a kingdom during minority or absent or disability of the sovereign. because all private bar guild members are appointed by Inns of Court. Inns of Court, there are certain private unincorporated associations in the nature of collegiate houses located in London, invested with the exclusive privilege of calling men to the bar, which is located in the Pope's owned and operated dependent city-state located in the city of London, called the Kingdoms of England and Ireland, now known as United Kingdom and the Crown, since the concessions of England to the Pope, 1213. We will establish perpetual obligation and concession. We will establish that from and proper the special revenues of the aforesaid kingdoms for all service and customs which we ought to render for them, saving in all things the penny of St. Peter. The Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 namely for the kingdom of England, and 300 for the kingdom of Ireland. And because King John gave them to the Pope and agreed to rent them back for 1,000 marks sterling per year. And this is Tomlin's Law Dictionary, Volume 2, under the definition of Pope. It's amazing what you find in there when you start doing these keyword searches. And not long after this, by a general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to the Pope Innocent III, and received them again and hold them of him under the rent of 1,000 marks. Which means all private bar guild members are foreign agents of the Vatican, which is why they're here under the foundation for the Federal Bar Association, 35 U.S.C. 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945 at 59 Stat 669. Fake magistrate judge Hal R. Ray and fake judge Reed O'Connor are both private bar guild members as required by the Vatican Civil Laws of Congress, called the Code of Law for the District of Columbia, now known as the United States Code. Whoops, looks like I got a spelling here. There we go. Matter of fact, that probably doesn't need to be capitalized. Section 631. No individual may be appointed or reappointed to serve as a magistrate judge under this chapter unless he's been at least 5 years a member in good standing of the bar. The Pope's owned and operated dependent city-state in the city of London, called the Crown, created the Cestui Act of 1666. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, that's the Roman cult, to be bound in conscience to account to a cestui use for the rents and emoluments of the estate. That's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of mortmain, which is what precipitated the War of Independence, as evidenced by the causes and necessities for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. That's dictatorship, folks. And the organic law of the Declaration of Independence shows it was listed as reasons for the Declaration of Independence from the Pope's owned and operated tyrant, the Crown of England. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation. That's talking about Roman law there, the canon law. For transporting us beyond seas to be tried for pretended offenses, Well, that sure sounds like that Sestake Trust, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments. He's abdicated government here by declaring us out of his protection and waging war against us. And that's what the Vatican does, okay? Under canon law, under Roman law, it's constant war. Because when they say he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, it can only be talking about the Pope's canon law, which is Roman law, which is also why millions of people are fleeing Europe at that time, because of the Pope's tyranny there. Tyranny is the exercise of power beyond right, which nobody can have a right to, and this is making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law, but his will the rule, and his commands and actions are not directed at the preservation of the properties of the people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that is put into any hands for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, and subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, Two Treatises of Government, Book 2, Chapter 18, Section 199 and 201. With the Spanish Inquisition and other oppressions, the use of information has a long history. For example, Henry VII, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the crown. Okay, that's the Vatican's crown. Okay. Blackstone, Book 4, Blackstone's Commentaries, page 310. Courts ecclesiastical. Spiritual courts, so those courts are held by the king's authority as supreme governor of the church for matters which chiefly concern religion. And that's Book 4 of the Institutes, that's Coke. And the laws of the Constitution, whereby the Church of England, the governor, 1, diverse immemorial customs, 2, our own provincial constitutions, and the canons made in convocations, especially those in the year 1603, much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. And that same stuff is going on today. That's what they're doing with Donald Trump. That's what they're doing with all sorts of people that we're dealing with, trying to help them get it resolved, trying to help them get it dismissed. The Pope's canon law, which is Roman law, Sestake Usufruct, was brought into America first with the Pope's 1871 Municipal Corporation at 16 Stat 419. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. And then with the Code of Law for the District of Columbia in 1901, Chapter 854, an act to establish a code of law for the District of Columbia, the legal estate to be the Sestake use. That's at 1431 Stat 1432. The Pope's minor estate, Sestake Usufruct, is now codified at 31 CFR 363.6 and are unconstitutional because municipal law was the law of the dependent papal ecclesiastical city-states. Civil or municipal laws that which every sovereign kingdom or state has appropriated for itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states. And that's Encyclopedia Britannica, or a Dictionary of Arts and Sciences, 1771, Volume 2, page 883. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, and between Tuscany, Modena, and Lombardy, and on the northwest and Naples on the southeast area, 17,822 square miles. Population in 1833, 2.742 million. Capital, Rome, population 153,000. Government, an elective monarchy, the Pope for the time being the absolute sovereign, with a consulting assembly of cardinals. Waterston Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Rome, the capital of the Pope's territories and of Italy, and anciently the Milrus of the Roman Empire. It was also called canon law. The civil or Roman and canon law, though they're not perhaps to be deemed proper parts of our written law, have undoubtedly had the greatest influence in Scotland. The power exercised by our sovereigns and judges have been justified upon no other ground than that they were conformable to the civil or canon laws, and a special, so civil and canon laws. The civil laws is the canon laws, and the special statute was judged necessary. Anyways, I could read all that stuff if you want to go back and read it. I'll upload the file. The Pope's ecclesiastical city-states are now called the Vatican, and it continues to this day. This is the Lateran Pact, Article 4, 1929. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as appertaining to the Holy See, forbid any intervention therein on the parts of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. Unconstitutional because of Article 1. Article 1, an amendment. Congress shall make no law respecting an establishment of religion, and the Pope's necromancy, sestike v usufruct, which is now called a minor estate, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor, and that's 31 CFR 363.6. And a minor can be anyone over the age of 18 who has failed to take control of the securities in the Treasury Direct account. It goes on and talk about that. The Pope's sestike v usufruct minor estate is a fiction of law which was invented by the Roman praetors under the pretense of doing equity, and owe their origin to the legislative usurpations of the bench. And the Pope's fictions of law are necromancy and satanic. I think I could probably, there we go. This is Deuteronomy 18:10-12. There shall not be found among you anyone that maketh his son or his daughter to pass through the fire, or that useth divination, or an observer of times, or enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, and because of these abominations the Lord thy God doth drive them out from before thee. Which puts you under the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as made by session of particular states and acceptance of Congress, become the seat of government. To deceptively assault people with a quasi-contract. I'm just looking on YouTube. I don't see any questions. A sumpsit. In its origin, an action of tort, a sumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of the distinct form of action, which superseded debt, became concurrent with account, with case upon a bailment, a warranty, bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts. Both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. They were contracted in law, but not in fact, being the subject matter of the fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it. Which requires the Pope's fiction of law, minor estate, U.S. citizen. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the District of Columbia expand to anywhere on the planet with their plenary power. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court, 1948. Which is why in the Kavanaugh hearings, when he was being interviewed for the Supreme Court appointment, they asked him, can we go after a U.S. citizen in Afghanistan? And he said, yes, you can. And because plenary power is a dictatorship under the Pope's canon law, which is Roman law, plenary jurisdiction of courts full and absolute power of the subject matter and the parties in the case. Plenary is full, complete, entire. Plenary, full, complete, the courts of admiralty and the English ecclesiastical courts, causes or suits in respect of different courses of proceeding, and each are termed plenary or summary. Plenary power is a plenary authority. It's a complete and absolute power to take action on a particular issue with no limitations. It is derived from the Latin term plenus, and plenary power, complete power of a particular area with no limitations. The term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The course has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. Fake Judge Hal R. Ray and fake Judge Reed O'Connor are operating as bought and paid for administrative clerks, masquerading as judges under the Pope's canon law, Roman law, in bad behavior, which is a non-judicial proceeding, because whenever a statute's involved, the Pope's fake judge is actually a bought and paid for clerk masquerading as a judge. When acting to enforce a statute and subsequent amendments to the present day, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administering or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes. As a ministerial clerk for an agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. Which means they were legislators engaging in legislative acts against me, a named individual, which is a bill of attainder or a bill of pains and penalties, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment, which says Congress shall make no law respecting an establishment or religion, because it's from the Pope's Roman law, also known as canon law, because they have imposed martial law rule, which is why we took up arms in 1775. And this is that cause of necessities for taking up arms, 1775. I'm not going to read it again. With the bankruptcy emergency, it's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent, HJR 192, 73rd Congress in session June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and as further evidence that the United States federal government exists today in name only. and that's U.S. Congressional Record, March 17, 1993. Since March 9, 1933, notice the same date, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's U.S. Senate Report number 93-549, dated November 19, 1973. Do you think anything's changed? Absolutely not. Martial law rule is the law of emergency and necessity. This is Ex parte Milligan, U.S. Supreme Court. There's three kinds of martial law. There's full martial law when actually invaded by a foreign enemy or insurrection. Troops are put on the streets. You see some of that happening right now in Los Angeles. Martial law proper is the law of the armed forces when a sergeant tells a private what to do, enforced by court-martial. Martial law rule is the law of emergency and necessity. It's used during peace times that can go on indefinitely. The Pope's bar members on the bench will tell you, I can do anything I want. And this is a non-ratification of the 14th Amendment by Judge H. Ella to the Utah Supreme Court in the case Diet versus Turner. This is a war over the intrusion of civil law and the common law. The court in Diamond v. Harris calls the civil law, which is statutory law, superior equity. And then the quote in the Diamond v. Harris, it's difficult to see how the courts of the state are to ignore the common law as a rule of decision when it's made so by statute and adopt the civil law, even though it had the merit of superior equity. And it goes on. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. That's why they can say, I can do anything I want in this court. Because common law is taken from the Holy Bible, and under martial law rule, equity does not follow the common law. Every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws its subsistence from the latter, the Bible. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guides by which we dissolve domestic frictions and the rule by which all legal controversies are settled, which makes it satanic. And the Pope's private bar guild Satanists are using the Pope's canon law, which is Roman law of capitis diminutio. Capitis diminutio is the maximum loss of status through the use of capitalization. Highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. To populate the prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. And because in the administrative proceedings under the Pope's canon law, which is Roman law, there are more people in prison in America as a percentage of the population than there are in communist China or the Soviet Union, or the worst dictatorship in history. And if there were Christians here, the Pope's private bar guild Satanists doing it would get their necks stretched. If a man be found stealing any of his brother or the children of Israel, and maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. Deuteronomy 24:7. And the Innocence Project estimates that 60% of prisoners are innocent, but it's such good business for the Vatican and their canon Roman law so-called courts, which is one of the grievances in the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people. Well, how do you destroy lives of our people except by putting them in jail? All of which has been planned and orchestrated by the Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. The Pope, the Vatican, now owns and operates the bankrupt 1871 corporation at 16 Stat 419, as evidenced by the Roman Achaea military staff that's planted on all conquered nations, that's sitting on the right side of the Speaker's podium in the U.S. House of Representatives, and the two Roman fascia, bundle of rods bound into a weapon symbolizing under the rule of a single man, that are on the wall of each side of the Speaker's podium in the U.S. House of Representatives, which is also why Nancy Pelosi, when she was Speaker of the U.S. House of Representatives, told members of Congress, we can't read this bill until after we pass it, because she was taking instructions from her Vatican handlers, all of which is evidencing the fact that the 1871 corporation at 16 Stat 419, currently operating in the District of Columbia, is a Vatican-dependent city-state, and the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican city-state and criminal matters that talks about concurrent jurisdiction in other states, which means the other papal states, like the District of Columbia and the City of London, United Kingdom Crown. And there's a picture of the Speaker's podium in the U.S. House of Representatives, and there's the two Roman fascias, and there is the Roman Achaea military staff. And this is that apostolic letter. When some matters are prosecuted in other states, the provisions in force in Vatican city-state, a concurrent jurisdiction shall apply. Entering into force on September 2013. And the Vatican's Pope Francis came and addressed his owned and operated Congress on 24 September 2015, and the Pope's satanic private bar guild members are assaulting people with their Roman fiction of law, minor estate, sestike use, usufruct, trust, necromancy, with presumptions of jurisdiction, presumptions of the office of trustee because the sestike be usufruct minor estate, and presumption of suretyship. I'm entitled to common law, not canon law / Roman law, as described in Article 6, Clause 2 of this Constitution for the United States of America. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties shall be made under authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And also in the Judiciary Act. Saving the suitors in all cases the right to a common law remedy where the common law is competent to give it, shall also have exclusive original jurisdiction, cognizant of all seizures on land and other waters as aforesaid made, and of all suits for penalties and forfeitures incurred under the laws of the United States, 1 Stat 77, Section 9A, and the Judicial Code of 1911. Because law of the land phrase is a convertible phrase with the phrase common law. The principle that no person should be deprived of life, liberty, or property except by due process of law did not originate with the American system of constitutional law, but was contained in the Magna Carta. sometimes referred to as Chapter 29, confirmed on the 19th day of June, 1215. Remember, that's after 2 years after the concessions to the Pope. The Welsh barons rose up in rebellion and stuck a sword to King John's throat and said, "We're not having any Roman law here." No freeman shall be taken or imprisoned or seized or outlawed or exiled or anywise destroyed, nor shall we go upon him nor send upon him but by the lawful judgment of his peers or the law of the land. It has even been said that the principle was known before Magna Carta and that it was originally designed to secure the subject against arbitrary acts of the crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as a part of the common law and has been a fundamental rule in common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in common law. And that's Book 16, American Jurisprudence, Constitutional Law, Section 543. And the common law and the law of the land has always been here from before the government was here. The individual may stand upon his constitutional rights, his rights such as existed by the law of the land, long antecedent to the organization of the state. That's before, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. And because their Vatican maritime codes only apply on the high seas and up to the high water mark or the first bridge of any navigable river, and the District of Columbia or any federal enclave is found in Article 1, Section 8, Clauses 17 and 18. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as made by session of particular states in the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. And I have been very vociferous about being posterity as found in the preamble and the living man and the living soul in every document filed into this case, evidencing the fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor's prejudgment on behalf of their private bar guild and their Vatican handlers. It's impossible for me to give any of these wrongdoers or bar member handlers or this court any authority over me, and John Marshall, the Chief Judge of the Legislative Inferior Supreme Court of the United States, agreed. Said it's impossible for me to confer sovereignty which will extend over me, and we already read this case, McCullough versus Maryland. I'm exempt from these wrongdoers and their Vatican corporation and their bar member handlers, not because of any formal conception or obsolete. Let's change this. Not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right is against the authority on which the right depends. And that's Cowan and Cole versus Polyblank. I already read that too. Matter of fact, this other stuff I read too. And fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor absolutely refused to regulate their property, and none of them produced any evidence of a bona fide contract. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor have ceased to represent the government. An officer who acts in violation of the Constitution ceases to represent the government. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor and their bill of attainder and their bill of pains and penalties are unconstitutional acts and a nullity. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It's in legal contemplation as inoperative as though it had never been passed. An unconstitutional law is void and is as no law. An offense created by it is not a crime. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Their so-called court is a kangaroo court. A kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, which the result is a foregone conclusion because of the bias of the court or other tribunal. And everything they did is a fraud and a nullity. Once a fraud, always a fraud. Things invalid from the beginning cannot be made valid by subsequent act. These are all maxims of law. A thing void in the beginning does not become valid by lapse of time. Time cannot render valid an act void in its origin. Out of fraud, no action arises. And any act by any government official to conceal a fraud becomes an act of fraud. It's a fraud to conceal a fraud, and fraud is inexcusable and unpardonable. Fraud and deceit should excuse no man, and any fraud amounts to injustice. Fraud and justice never dwell together. What is otherwise good and justice, if sought by force or fraud, becomes bad and unjust. And their bill of pains and penalties, fake judgment, is brutum fulmen. Brutum fulmen is an empty noise, an empty threat, a judgment void upon its face, which is in legal effect no judgment of all, and by which no rights are divested, and from which none can be obtained. And their fake judgment is void and an absolute nullity. A void judgment is one from which inception is a complete nullity and without legal effect. A void judgment is one which has no legal force and effect whatever. It's an absolute nullity. Its invalidity may be asserted at any time by any person whose rights are affected at any time and any place, and it need not be attacked directly, but may be attacked collaterally whenever and wherever it's interposed. A void judgment, insofar as it purports to be a pronouncement of a court, is an absolute nullity. A void order may be attacked directly or collaterally at any time. A void judgment is one which from its inception is and forever continues to be absolutely null and without legal efficacy, ineffectual to bind parties or to support a right, of no legal force and effect whatever, incapable of enforcement in any manner or to any degree. Not every action by any judge is an exercise of a judicial function. It's not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void and of no legal force or effect. And fake Judge Hal R. Ray and fake Judge Reed O'Connor are both personally liable in their private capacity. Judge loses his absolute immunity for damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. Fake Judge Hal R. Ray and fake Judge Reed O'Connor, fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor unfiled the 78 criminal complaints that I filed into the case in support of their Federal Bureau of Investigation refusal to investigate the 78 criminal complaints, in support of their targetedjustice.com agenda to refuse to investigate felonies against targeted individuals like me in the hope that I'll exercise my right to resist their unlawful arrest and their unlawful theft of my land with lethal force if necessary, as found in United States versus Schooner Amistad, and so they will have an excuse to murder me and say they killed another sovereign citizen terrorist for their communist handlers in support of their war crimes agenda to take reprisals against anybody who thinks they have rights for their political beliefs, all of which is in support of their private bar guild and their Vatican handlers who love satanic blood sacrifices to the Roman cult god Baal. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor intend to be accomplices in conspiracy with the County of Montague thieves and their Federal Bureau of Investigation accomplices to facilitate the theft of my land under color of law and my murder for their private bar guild and their Vatican handlers that love satanic blood sacrifices to their Roman cult god Baal. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor have demonstrated they intend to conspire with the County of Montague thieves and their Federal Bureau of Investigation accomplices to engage in a seditious conspiracy to overthrow this Constitution for the United States of America for their private bar guild and their Vatican handlers. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor have demonstrated that they intend to perjure their oaths of office to the supreme law of the land under the Vatican Code of Law for the District of Columbia, now known as United States Code 28 U.S.C. Section 453, which says every judge or justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and the rich, and I will faithfully and impartially discharge and perform all the duties incumbent upon me under the Constitution and laws of the United States, so help me God. And they have absolutely no intention of being neutral or unbiased. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings, but prejudge this case from the beginning to bring the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17 for their Vatican handlers. Sestake v. Usufruct minor estate, and it failed to matter what I said or did because they intended to sell me into slavery from the beginning in support of their Vatican handlers and their County of Montague private bar guild buddies, because their oath to their private bar guild is also to their god Satan, who is the father of all lies. You have your father the devil, and the lust of your father you will do. He was a murderer from the beginning, and abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh of his own. He is a liar and the father of it. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor intend to be accomplices in conspiracy with the County of Montague thieves, and their Federal Bureau of Investigation accomplices intend to assault me with their satanic religious ceremony, with their fraud and their lies and their deception and their necromancer and their involuntary servitude, slavery, in support of their private bar guild and their Vatican handlers that love satanic blood sacrifices for their Roman cult god Baal. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor are bought and paid for whores selling their just us for their Vatican handlers. And signed and sealed in red ink under penalties of perjury without your Vatican Corporation, 28 U.S.C. 1746-1. And then that's the usual stuff that I say at the end. I, GlennWinningham, House of Fern, demandant, sui juris, natural man, living in the Republic that I prescribed and read the foregoing facts, and in accordance with my best first-hand knowledge, such are true, correct, complete, not misleading, the truth, the whole truth, nothing but the truth, before God, angels, and anyone who reads this document as witnesses, pursuant to your rules of evidence. So I'm thinking about adding in something about my affidavit of life, but anyways, I think that the fact that it's filed and I got a certified copy back now, I think that they got a problem. But anyways, so does anybody have any questions?
Why wouldn't you make why wouldn't you make the affidavit of life an exhibit?
Sorry?
Why wouldn't you make your affidavit of life an exhibit?
Well, I haven't really attached any exhibits. I've been thinking about incorporating some exhibits into it. But like that, the notice and demand that I sent to the Montague County thieves, yeah, why wouldn't I? That's the question. And then how to do it. That's the question. It's not really why I wouldn't. I'm thinking about doing it, but the question is how do I do it? How do I incorporate it in there without adding a lot of stuff? Just add a reference to it, see attached here too, or something like that, eh?
Yeah, I see that you don't want to. Well, you've already basically outlined it all in your explanations of what you're submitting. It's already there.
Sorry?
I'm roboting, aren't I? But you've already explained yourself, so it's...
Yeah, I went through it
in pretty good
detail about their bills of attainder and the fact that it's a fiction of law, and and so they're assaulting me with their fiction of law, which is a legislative act, and it's a bill of attainder, and it's unconstitutional, and they're deemed to know the law. Um, Actually, I need to add that in. Yeah, I do. Let's see here. Where can I get that from? Hmm. Yeah, I need to add that for sure.
I just believe it flows.
Sorry?
I believe it flows with the information they're submitting.
Here we go. This is perfect. So let's add that in. We'll go up before the rants. Let's see here. That's where we're going to add this in.
Capitis odious, or I'm not pronouncing that correctly at all, but after that. When they've converted the name into all caps. What do you call that again? Capitis deus.
Capitis. What?
Well, when they did the conversion of our names into the all caps, you mentioned it was
That's
Capitis
capitis
deus.
diminutio.
Oh, okay, there we go. Thank you for the clarification.
Diminutio.
I won't say it 10 times fast.
Officers of the court have no immunity when violating a constitutional right because they're deemed to know the law. Yeah, that's a good one to put in there. Yeah, yeah. There we go. That was a good one to put in there for sure.
Okay, read it through.
Well, I inserted that right here, right? This was after the stuff about it's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary. They haven't produced a bona fide contract. They've ceased to represent the government. They're deemed to know the law because they're officers of the court and have no immunity. Their bill of attainders are unconstitutional acts and a nullity. Their so-called court is a kangaroo court. Everything they did is a fraud and a nullity, and it just goes on. Yeah, and then so I go through that, and now I'm going to really start railing on the bastards, and they want me dead, and yeah, in a seditious conspiracy to overthrow this Constitution for their private bar guild and their Vatican handlers. They intend to perjure their oaths to the supreme law of the land. I should probably throw in that they've engaged in treason. Yeah, I think I should. Where am I going?
What about their oath?
Sorry?
Their oath stuff. What about their oath stuff?
Their oaths. What do you mean?
Well, they're obligated by their oath.
I've got that in here already.
Sorry, I missed that. Got it.
Right here. Fake judge, fake magistrate judge Hal R. Ray, and fake judge Reed O'Connor have demonstrated that they intend to perjure their oaths of office to the supreme law of the land under the Vatican Code of Law for the District of Columbia, now known as United States Code 28 U.S.C. 453, and this is their oath of office. And they've absolutely no intention of being neutral or unbiased, but prejudged this case from the beginning to bring District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17 for their Vatican handlers. Anyways, don't get me going. So that's talking about their oaths.
Yeah, you've got it there, clearly.
Maybe I'll throw something in here. Let's see here. Um, Yeah, I'll have to adjust this one, see how I can. It needs to be shrunk down a little bit, I think.
You're going to upload that to your page, correct?
Yeah, I can do that right now, in fact.
Okay, good.
Does anybody have anything that they want to talk about as far as this is concerned? I guess not, eh? How long has we been going on with this? Oh, it's an hour and a half.
Not long enough.
I wouldn't. On YouTube, they're asking if you should get the birth certificate authenticated. I wouldn't. It's up to you, but I wouldn't. That's there's a thing in equity called the clean hands, and if you go and do that stuff, then you don't have clean hands. And so my attitude is it's a fraud and a nullity, and I want it dissolved and liquidated yesterday. And I don't care what you do with the fake money in it. You can put it up your rectal orifice for all I care. But yeah, this notice of void judgment is going to get filed into this case, into my federal case, and so I'm going to be railing on the fake judges. Anyways, let me. Oh my god! Right, that's what I was doing. I was uploading it. Yeah, I'm going to file it into the case, get a certified copy, and then I'll probably add it into my appeal. Okay, I uploaded it, the Word file.
Thank you. Thank you.
So, did anybody enter the contest for my book?
Yep.
Oh gosh, you haven't looked. Looking in
57,
the, yeah.
57 entries. You want me to do it now?
Whatever.
Okay, I need the screen share, that's all.
Okay, well, you can go ahead and do that as far as I'm concerned. Do I need to stop screen sharing?
No, I think it'll push your screen to the side.
Okay, well, I just stopped anyways.
Okay. All right, hang on one second.
57. Wow. Well, there's other people on YouTube that are wondering if you go to Telegram, you can still enter them. Do we want to give them some time to enter at the last minute here?
Definitely. We want to open it up to as many people as possible. Can you go over that next document?
How many are watching on YouTube, Glenn?
Well, it says that there's 19. There's one guy that said he didn't know there was a contest. Yeah, there's a contest for copy my book. I don't know is there an entry fee? What's the entry fee or the entry requirement?
I put a poll up in Telegram on a bunch of different groups, and they just have to answer the poll. But what I could do, which would be the easiest right now, is for you to have them on YouTube type in their name or their screen name, and I'll enter it in. It's
Okay.
on a wheel. It's an automated wheel, so no one is going to be in charge except for the electronic wheel.
Okay, so there's a random number generator or something like that, eh?
A random name, yeah.
So anybody that's interested, type in your screen name, I guess, in YouTube in the chat, and then Queen will add you onto the. There's a poll, so you're going to enter in the poll for them too, then, or what?
Yeah, I just enter them into the wheel, that's all.
Okay.
So let me go on your YouTube now.
Well, there's nobody really responding. It doesn't look like. Oh, Brennan Vera is respondent. Brennen and Vera.
Okay, I was doing two different things. Can you just repeat that for me, please?
Brennan Vera, Brennen, and then Vera is the, and then there's another one, Silent Walk.
Okay, is that it?
Yeah, looks like it so far. How do they? I mean, I'm going to have to ship them the book. How am I going to find out their address and all that? Do they have to contact me privately or something?
Yeah,
Because
well, when they see the screen name that gets picked from, if it's one of them on YouTube, yes, they'll have to email you.
okay, so
But
there's
if
some
it's
more.
anyone here on Telegram, I can just message them and get their info.
There's more. There's
Okay, go ahead.
there's a T space H. There's a Luke Rocks a lot. LUKEROXALOT. There's a Kleina Renee, KLINA-RENEE.
What was the last part? CLINA what?
KLINA-RENEE.
Okay.
Can I use that for a past judgment for DUI in driving without a license? I don't know what you're talking about. This is basically a contest to win one of my books. Okay, well, they seem to be coming in kind of slowly, but let's give them a few minutes and see if anybody else shows up. I'm going to step aside for a minute and get some ice for my tea. Well, that looks like about it. Nobody else has put their name up there.
Okay. Let me share my screen. Can we see the wheel?
Yeah, let me put it on. Let me share it too, so that people on YouTube see it. There we go.
Okay, we ready?
Just a second. Let me check and make sure it's visible on YouTube.
Good luck to all the entries.
Okay, I'd say it's available on YouTube.
All right. 1, 2, 3.
Isabella George. Okay, well, that wasn't anybody on YouTube. That's somebody on Telegram.
Yeah.
Okay, well, let me know the address you want me to send it to.
All right. Well, I'm going to post it and then I'll message her.
Okay.
Well, that was fun. We do this often.
Well, you got quite a few people to respond. I'm kind of surprised you got so many to respond.
Well, I'm looking forward to the second edition, so we'll be doing it again, Michelle.
I was surprised at how many people responded. The address would have been if you won the book, because then I'd need to ship it to you. That's all. I'm talking to somebody on YouTube. And sorry, Ty Robin, you didn't get in there. Looks like someone added their name there, but it was quite a while, and we didn't have it. I don't know. It could be a lag in the chat getting through on YouTube too, but maybe next time.
There you go. After you do this, finish watching or doing this case, you can start working on the next book.
Yeah, actually, I'm thinking about. I got to talk to Mike tomorrow. He's the co-author and he's the publisher, and I got to talk to him tomorrow about how many books he's got in stock, because we probably need to get rid of the ones he's got first, and then I'll maybe start thinking about revision, because a lot of stuff has happened since I wrote that book. I'll tell you, so I could add in quite a bit of stuff.
Definitely update the new seating of Trump's second sitting.
Right. Well, there's a lot of stuff that happened. I mean, a lot of stuff. A lot of rumors. A lot of rumors,
yeah.
and then the stuff that actually that we know happened. You know, we're all pawns in a big game of chess. Like these riots and stuff that's going on right now.
Definitely. I'm glad to see that the excitement for the book has motivated you to get going on your next one.
You never know. Yeah, might be. I was listening to 107 today, and he didn't seem to be too worried about most of them. They're not really riots. There's people demonstrating, and peaceful demonstrations are okay, It's just that when it turns violent, that it can be a problem. Um, but the so L.A. seems to be the only place where there's supposed to be riots. But I'm hearing rumors there's going to be a bunch of stuff going on in Texas tomorrow, and I'm in Texas, so I guess we'll see.
Yeah, they're actually, I think, like the Rainbow Committee because they're protesting for immigration.
Well, you know,
In New
107,
York, anyway. In New York. What did 007 say about it? Or,
he said that he knew people that were self-deporting, and they'd been here for many years, 10, 15, 20 years, but they were going to self-deport because they wanted to be able to come back. And they were concerned because there's people that are getting picked up that have been here a long time, and they get deported, and if they get deported under those circumstances, they can't come back. And so there's like this one guy, he said he took 20 of his family members and they left. They went to Mexico, and then plus on top of that, they were concerned that there's going to be a huge numbers of people going to Mexico, and they wanted to get there first. Anyways, um, yeah, and they wanted to come back, and so they wanted to have that option available, and in a year or two, when things settle down, they wanted to come back. I think that, quite frankly, I think there's going to be a North American Union here before too long, and the people in Mexico are not the problem, anyways. It's the people from the Middle East that are here, and the people that are from China that are here. You know what I mean? And even those, if they're here peacefully and they just want to, freedom, then that's hey, everybody's here for that. But if they're here as part of the communist agenda, then they're not going to like what's going to happen because they're, you know, yeah, no shit. So we'll see. That's all I can say. Um, you know, I Cliff High said his data sets, the emotional tension is going to go up in June, and it's going to go up even more in July. And then in August, it's going to settle down. Maybe I'll even show that. Maybe I'll pull that chart up here. Maybe I'll do that.
yeah, and post it in the room too. And then after you're done, I just thought about something. Get that name from that guy on YouTube because if Vanessa doesn't respond by next week, then I want to spin the wheel again because, we'll give her a week to claim the book, right? And then it's not really fair that, we kind of let it go on and on. So get the gentleman's name who wanted to join the entry because they're possibly. Well, get the name of the gentleman that wanted to be added on to the chance to win the book because if the person that did win doesn't step up, then we got to do it again, right?
Oh, okay.
They are they're looking for people to return back to their country is when we are facing wars, right? So when there's a war breaks out, let's say anybody can be an enemy to this country. It could be China, it could be Mexico, anyone. And if that happens, they definitely will gonna be detained within this country.
Right.
And it's better that they go back because there's most likely there will be a war. When the Israel is surrounded by all the nations, Bible talks about there will be a war, definitely.
What the way 107 explains it is that if they think that they're going to go and take over Los Angeles, the Marines have something else to say about it, and they're not going to win, and they're going to wind up in prison. And so, the Marines will win. Anyways, okay, here I'm going to share this because I think this is talking about emotional. This is Cliff High's chart that he did. And you can see it on Telegram. Let's see if it's on. It should be on YouTube too. Just going to give it some time. The YouTube is a little bit of a lag. There we go. It's on YouTube. So this is a weekly emotional tension chart for 2025. And right here, well, it's week 2, June, week 1, week 2, and week 3. And the 77 and 80. Okay, the emotional tension is from Cliff High. Starts in April, week 1, week 2, week 3, and 4. And then May, week 1, 2, 3, and 4. June, week 1, 2, and 3, and 4. July. So to give you an idea, the June, we're actually in week 2 right now. So and this is something that he picked up in his data sets here, probably about 6 months ago. And he said, stay alive in 25. And so this is the weekly. And so you can see what's going on. There's huge stuff going on. Israel just attacked Iran. And it's going to continue getting more tension this month. And then July, it's going to get even worse. And then August, it's going to settle down a little bit. In September, it'll settle down a little bit more. But then October, it's going to be even worse than all of that. So, what's going to happen? I have no idea. But you can see it happening. It's the shit is hitting the fan. And so, I'm not going to any demonstrations. I can tell you that. I'm avoiding that stuff like the plague. It may be
You'd be a strong speaker on one of those platforms. What do you mean? That's not your scene.
Sorry?
I said you'd be a strong speaker on one of those platforms. That's not your scene at all, or what?
I'm not interested in confronting the government. I love what Trump is doing, quite frankly, and so I support him 100%. And I think that we have a communist insurrection, and the communists are the ones out there causing the trouble. Whether the people themselves might be just useless idiots, but it's really the communists that are causing it, and the government's going to deal with it, and they have my support. And so, a matter of fact, it might come down if they call up the militia. I might be in the militia or something. Who knows? I have no idea. But that there is always that possibility too. So, anyways, the point is this is an weekly emotional tension chart starting in April, and it goes through the end of the year. Yes, it does. It goes through the end of the year. And so this is what Cliff High's picked up on his data sets, and he's nailing it so far, I got to tell you. So what we need to do is, what Cliff High said, stay alive in 25. So, anyways, I suppose that's about it, eh? We're done?
I guess so. Thank you so much for coming on tonight. I appreciate you coming back after your holiday and doing your book giveaway. That's I wanted to give out mine, but mailing anything out from where I am is kind of useless, right?
Well, the mail
We've
is
proven
just
that.
the mail is really bad everywhere. I'll tell you, it's bad here too. The mail
Yeah,
is.
here people. Yeah, people have complained about USPS too.
It used to be that you could put something in the mail in San Francisco, and the same day it'd get to Fairfield, California, which is basically like 75 miles away, and it'd get there. It'd be delivered, and and
Mm.
it used to be that the mail was. I mean, the mail was so good, I just couldn't believe it. But it's certainly fallen off its pedestal. I'll tell you, it's big time fallen off its pedestal. Um, so anyways, if that's about it, I guess we'll call her quits for this week, and we'll do it again next week, same time, same place, same channel.
Okay, get that gentleman's name who wanted to enter just in case.
Okay, well, it's
Vanessa doesn't
Ty
come forward.
Robben, Ty and Robben,
ROBBN. Okay, I will put him.
Robben, and that's on
E-
YouTube. And that's in case that you can't get a hold of the winner and you have to do another draw. But we'd probably do it next week, right?
Right. I
Yeah.
don't think so.
So he'll add, but we'll be doing another draw if this draw doesn't if they can't get a hold of this lady, then we'll have another draw next weekend, next Friday.
Fair enough.
All
Fair
right.
enough. Sounds good.
Looks like TH just joined your Telegram.
Oh, is that right?
That's
Okay,
on YouTube.
great.
Somebody just joined Telegram.
Okay, good. Well, we'll get him in that, and we'll do the wheel again idea for the next edition.
All right. Well, I guess that's about it. And
Yeah,
we'll
I'm
see you
gonna.
guys next week. Same time, same place, same channel. Next Saturday,
Yeah,
next Friday.
I'll count on it, and I'll be talking to you during the week regarding the book, the next or the second book.
Okay.
Okay, you take care and have a good week.
Thanks. You guys take care too, and we'll be in touch.
Thank you.
Have a good night.
See you later.